Good afternoon, everyone, and welcome to our training, How to File for Temporary Protected Status, TPS, an overview in 2023. My name is Allison Cutler, Supervising Attorney of the Pro Se Plus Project, which is a collaboration amongst legal service providers and community-based organizations that aims to empower recently arrived migrants with the knowledge and tools to advocate for themselves and mobilize community supporters. Let me introduce everyone to our presenter today, Benjamin Remy, who is the Senior Staff Attorney of the Pro Se Plus Project. He has been a trial attorney for the past 5 years, the last 2 of which were with New York Legal Assistance Group. He now focuses on providing pro se assistance and community outreach to recently arrived immigrants in New York City. And thank you, Ben.
Thank you so much, Allison, and good afternoon to everyone with us here today. So before we get started and examining some of the subject matter that we'll be looking at today, just as always, a huge thank you from us here at the Pro Se Plus Project at NILAG, and as the collaborative overall for being here today, for taking this training, and of course for volunteering with us, whether you have done so in the past or will do so in the future. Our project could not work without having such awesome volunteers. So from all of us here, just a huge thank you. So with that being said, and that out of the way, what we're going to be talking about today is how to file for temporary protected status. So essentially, just looking at an overview of how to do this in 2023. So just in terms of kind of a roadmap for everything that we'll be looking at today, we're going to start out by looking at some immigration procedural postures. We're going to take a look at temporary protected status eligibility. We're going to look at inadmissibility and bars to TPS eligibility. We're going to take a look at the TPS application itself. We'll discuss advanced parole for a bit. And then, of course, preparing to file, and then what happens after the filing. Now, before we get started and really jump into these applications themselves, I highly recommend that everyone should download a copy of all these forms. So Form I-821, that's your TPS application. The I-765, that's your application for work authorization, as well as the I-912, the I-912, which is the application for a fee waiver, which we'll also discuss today. It'll just make it a little easier while I'm going through all this information, just to follow along. So just a little bit more about who exactly we are. So we are the Pro Se Plus Project. We focus on community education, community advocate trainings. We conduct screenings of recent arrivals, and we also provide pro se application assistance and representation. We have a link to our website down below. Now, the Pro Se Plus Project, we are a collaboration between community-based organizations and legal service providers. We aim to empower and mobilize communities with education and support. We also aim to create and deliver robust community education workshops explaining U.S. immigration, including eligibility requirements for asylum, TPS, other forms of relief, as well as the way in which immigration procedures function, as well as representation. Now, we also, such as today, provide trainings for our community supporters. So this includes volunteers, pro bono attorneys on understanding eligibility for asylum, TPS, work authorization, all those sorts of things. So where we're going to start today, in terms of actually diving into the immigration aspect of this, we'll be taking a look at some immigration procedural postures. Now, anytime dealing with immigration, just looking at this from a bird's eye view, there's 2 big agencies that you'll always want to keep your eye on. So these are, first of all, the Department of Homeland Security. Now, the Department of Homeland Security, or shorthand DHS, also contains three sub-agencies. So we have ICE, that's Immigration and Customs Enforcement, CBP, that's Customs and Border Protection, as well as USCIS, that's U.S. Citizenship and Immigration Services, which is essentially the adjudicative arm of DHS, which deals with affirmative applications. Now, we also have the Department of Justice. So this consists of the Executive Office of Immigration Review. So these are our immigration courts, as well as the Board of Immigration Appeals, shorthanded to the BIA, which is an appellate body and essentially the highest court in the realm of immigration. Now, it's also really important to keep in mind that community members may be interacting with more than one of these agencies at the same time. And it may be unclear at times. So it's always really important to know which agency you're dealing with, which agency or agencies a community member is dealing with before beginning any type of immigration work or immigration assistance. So the best place to always start is with the actual entry. So how did the community member or the individual that you're working with enter the United States? So the first really common method may be an entry without inspection, which we shorthand to EWI. So this is essentially a situation in which someone has crossed the border without presenting themselves to immigration officials. We also see quite a bit of our community members that have been allowed to enter the United States via humanitarian parole. Now, we also really want to emphasize this today because humanitarian parole has become increasingly common, especially over I would say the last couple years, last 3 years or so, and we're seeing it a lot with our community members on the ground. So, what is humanitarian parole? Humanitarian parole allows for the entry of non-citizens into the United States. It does not confer permanent immigration status. It can, in theory, be extended. However, you should still and you can and still should seek other immigration relief. If the possibility arises down the road, it would also allow someone to be able to adjust their status through family and other means. And then finally, we also have release on recognizance, which we shorthand to ROR. All right. So just a bit more about these agencies here. So ICE and Immigration Court are not the same. And I'll repeat this just because it's very easy, especially for our community members, to be at times confused. Where am I getting paperwork from? Where am I supposed to go? So ICE and Immigration Court are not the same. So individuals may have court dates and they also or may not and or have check-in dates with ICE. Now, ICE itself, they are charged with enforcement and monitoring within the borders of the United States. So they may require non citizens to appear or check in to monitor and enforce. They also may issue charging documents that require individuals to go to immigration court. And we'll take a look at some of these documents a little later today. And then we also have immigration court itself. So, just as an example, this is where asylum claims and any other forms of relief are decided, are maybe granted, maybe denied. One really important note when it comes to immigration court is that non appearance can result in someone getting a removal or deportation order. Now, just again, some notes that we have from our work. The vast majority of individuals who have entered over the border that we have seen have been asked to check in with ICE. So a majority of our community members will be on some sort of ICE check-in schedule. The vast majority as well are already in immigration court where it's potential that they have a removal order or could receive a removal order. And also, just to keep in mind, note that many have been allowed into the United States in order to litigate asylum claims, to present their asylum claims before a judge. So, to enter the United States for the purpose of seeking asylum. All right. So, this is a number that you'll hear me talk a lot about today, and there's a really good reason for that. So, this is going to be your most important number when it comes to immigration. So, the alien number, otherwise known as the A number. This is a unique 9-digit number. It's given to every individual who comes into contact with border officials and enforcement officials or applies for any sort of status with immigration. It's listed on almost all documents that are issued by DHS and EOIR. Most applicants will not have an A number unless they were paroled into or released into the United States at a border. And people who have entered on visas, could be a tourist visa or student visa, do not have an A number. And we'll take a look at some immigration documents, some of the more common immigration documents, so you'll know where you can always find this number. So the first paper that we'll look at today, it's a very common one that we see with a lot of our community members, is a release on recognizance order. So top right corner, you'll always be able to find that A number. So always keep in mind, top right corner, that's where I'll find the A number. As well, if you look at about the middle of the page here, you'll be able to see when if an individual has been scheduled for a check-in with ICE, when that appointment is, when and where that appointment is. And then just to keep in mind, to go back to our theme of immigration court and ICE are not the same, this will be an appointment date. It is not a court date. Now, to make things even more confusing, sometimes those dates match, but when you're looking at this particular piece of paper, this will indicate an appointment with ICE. So some more common documents that we see quite a bit are these parole documents. So on the parole document, if we take a look at our left-hand side here, right at the top, you'll be able to find that A number. Now, two kind of different but important pieces of information you'll also see on a parole document will be in about the middle of the page, how long that actual parole is valid for, and more towards the bottom, that date at which that parole was granted. And then finally, another, and I would say probably the most common document that we run into is what's called a notice to appear. So this is what we had mentioned earlier about a charging document that's issued by ICE. This is the document that actually commences the removal proceedings process, that actually places the individual into immigration court proceedings. And this is issued by ICE. Now, if we take a look at the document itself, again, if we look at that top right-hand corner, we'll see the A number. If we look in the middle here, we'll see the date of entry, and at the bottom, we will see the hearing date and location. So the actual hearing date and time, where the immigration court hearing is when the actual court hearing is scheduled for, as well as where. So what particular immigration court that individual may be in. Now, just to go back to my point here about this document starting the removal proceedings process. For those proceedings to actually start, this document must be served, and what we call docketed. So docketed means that ICE has actually placed or served the immigration court with this notice to appear, and they will start to appear in the EOIR system, which is how you're able to confirm that yes, this is an actual hearing date, this is the actual immigration court, and we'll discuss this a little bit more in depth later, but a good way to always just check and make sure that these documents match up, that an individual knows exactly when or if they are scheduled for an immigration court hearing. So, a little more on that. How do we confirm if an individual is in removal proceedings? So, I always say the portal is king. So, immigration court future court dates and outcomes of cases can be found through this link below. So, this link will take you to the EOIR portal, the automated case information section, and it will always have your future court date. If in the situation that there may have been a removal order. If someone didn't know they had court and didn't appear, it will indicate that there was a removal order issued as well as the date at which that removal order was issued. So just to hammer this again one more time, always check the portal. So anytime that I or my team start with any sort of immigration case, helping any sort of helping an individual with any sort of application, we always check the portal. That is always our first step. Now, in the event that the portal may be down or someone doesn't have access to the portal, you can always call this number. We used to always call it the EOIR hotline. A lot of us will remember the days we didn't actually have the portal, so this number we would be on the phone all day, calling this number to check the status of cases. So it will contain the same information as that actual EOIR portal page. So you go ahead and call that number, enter one for English, and you'll actually enter, once again, that alien registration number, that A number, that super important number that you'll be able to find on all immigration documents. All right. So getting into more of the fun stuff here, we're going to talk a little bit about temporary protected status, TPS, eligibility, how someone qualifies for TPS itself. So that will, of course, beg the question of what is TPS? What is temporary protected status? So, TPS is granted to eligible nationals of a designated foreign state or to eligible individuals without nationality who last habitually resided in the designated foreign state. So, the Secretary of DHS, Department of Homeland Security, can designate a country for TPS due to conditions in the country that prevent its nationals from returning safely. So some examples may be natural disasters, wars, epidemics, things in that vein. So the statutory authority found is for this is found in INA, Immigration and Nationality Act, Section 244, as well as the regulatory authority in 8 CFR 244, and TPS becomes effective when notice of the designation itself is published in the Federal Register. Now, what does TPS do? So, during the TPS designation period, an individual with an approved TPS application can remain in the United States, or prior to it being granted, is eligible to remain in the United States. They may not be removed from the United States, and they are authorized to obtain employment authorization. Now, they may also apply for and be granted travel authorization as a matter of discretion. Now, just a really important point to emphasize here, TPS does not result in or lead to lawful permanent resident status. So, just one more time, it does not result in or lead to lawful permanent resident status. So, not something like asylum, where if asylum is granted, it does provide a pathway to lawful permanent resident status. TPS does not do so. All right. Now, just to be a bit more granular in terms of eligibility, to be eligible for TPS, a person must be a national of a TPS designated country or have last resided in the country as a person without a nationality. They must file for TPS during the open initial registration or re registration period or be eligible for a late initial filing. Now, they must have been continuously physically present in the United States since the most recent designation date of the country, and they need to have been continuously residing in the United States since the date specified for that country. Now, exceptions do exist to these physical presence and residence requirements for what are called brief, casual, and innocent departures. And the final criteria is that you must be admissible as an immigrant, although there are some exceptions, which we will discuss. So, in terms of just a really broad view here, just a quick look at the status of TPS designations in 2023. So, all the recent updates and all the current country designations that we have as of 2023. So, the countries that are currently designated for TPS are Afghanistan, Burma, Myanmar, Cameroon, El Salvador, Ethiopia, Haiti, Honduras, Nepal, Nicaragua, Somalia, South Sudan, Sudan, Syria, Ukraine, Venezuela, and Yemen. Now, it's really important, really essential here so that we keep in mind that each individual country has very particular eligibility dates, designation durations, and registration periods. And these also change over time. So it is absolutely critical to double check the specific criteria by country on a case by case basis. So for information on current designations country by country, you can go ahead and visit this link that we have below. And again, just to emphasize this, whenever you're starting with any sort of TPS case, always start with that country specific page. So if you're doing a Venezuelan TPS case, you want to make sure that you go to the specific Venezuelan TPS page to make sure that you have all the correct requirements, all the correct criteria before you start working. So, just as a bit of an example here, we'll take a look at Venezuelan TPS and specifically the 2021 designation. So, Venezuela was initially designated for TPS on March 9th, 2021, and has recently been extended through September 10th, 2025. So, just to look at how some of this eligibility criteria can work, continuous residence must have been since March 8th, 2021, and physical presence must have been in the United States from March 9th, 2021. Now, the current re-registration period is January 10th, 2024 through March 10th, 2024, and only those who applied during the initial registration period may re-register. Now, we picked Venezuelan TPS for a reason as an example because we've had really recent updates and it has now a new designation. So, On September 20th, 2023, Venezuela was redesignated for TPS. So, our new requirements under this new designation are continuous residency since July 31st, 2023, and physical presence here in the United States from October 3rd, 2023. Now, we also focused on this as an example because at this point in time, there are an estimated 50,000 Venezuelans in New York City who are eligible to apply on the basis of this new 2023 designation. So the registration period for Venezuelan TPS, based on the 2023 designation, is from October 3rd, 2023 to April 2nd, 2025. So moving along here, we're now going to take a look at inadmissibility and some bars to TPS eligibility. So, in terms of bars to eligibility for TPS, a person is ineligible and barred from receiving TPS if they have been convicted of any felony committed in the United States or have been convicted of at least 2 misdemeanors committed in the United States or are described in INA Section 208B2A for various factors such as participation in the persecution of anyone based on race, religion, political opinion, etc., being a danger to the security of the United States, or being involved in terrorist activities or organizations. Now, what is admissibility for TPS mean? So applicants must be admissible as immigrants to the United States under the admissibility grounds set forth in INA Section 212. Now, again, to go back some of these bars, these include criminal bars, controlled substance offenses, terrorism-related inadmissibility grounds, which we shorthand to TRIG, firm resettlement, and trafficking. Now, there are waivers available, and we will discuss these a bit more in depth after we review some more of these bars here. So, in terms of criminal bars, a person is not eligible for TPS if they have been convicted of a felony or 2 or more misdemeanors. Now, a felony in this context means any crime which is punishable by imprisonment of more than 1 year, regardless of the actual period of confinement. What does a misdemeanor mean in this context? This is any crime which is punishable by up to a year in jail. Now, here in New York, any conviction for an A or a B misdemeanor is a misdemeanor for purposes of TPS. So, what are some things that are not misdemeanors? So, the following violations, per recent USCIS guidance, are not offenses that will constitute misdemeanors for the purposes of TPS. So, these include traffic infractions, disorderly conduct, loitering, harassment, speeding, and littering. Now, another really important point here, how do we define a conviction in this context? So, a conviction is a formal judgment of guilt entered by a court. Now, if adjudication of guilt has been withheld, we can still have a conviction where a judge or jury has found the alien guilty, or the alien has entered a plea of guilty, or nolo contendere, or has admitted sufficient facts to warrant a finding of guilt, and the judge has ordered some form of punishment, penalty, or restraint on the alien's liberty to be imposed. Now, whenever we take a look at criminal history, we always want to ask the applicant, we always want to ask the community member whether they have received any convictions, arrests, citations, indictments, charges, fines, or any periods of imprisonment. So always ask in as many ways as possible whether an applicant has ever been arrested or had any contact with the police. So obviously here in New York, but anywhere else as well. If the applicant has ever been to criminal court, they must get a certified certificate of disposition from the court clerk, and the applicant should request all records, even records for cases that were sealed. Now, another bar to take a look at here is the controlled substance offense bar. So a person may be barred from TPS for a misdemeanor conviction or even admitting to the elements of a controlled substance offense without a criminal conviction. So this is defined under 21 USC section 802 It contains a comprehensive list of substances, and this does include marijuana. It can also include paraphernalia crimes, and it can include driving under the influence, non alcohol related. And another bar is what we talked about just a little earlier, the trig bar. So the terrorism related inadmissibility grounds. So someone is inadmissible if they have engaged in terrorist activity or has been associated with groups considered terrorist organizations by the US government. So, what does terrorist activity mean? Terrorist activity includes any activity that is unlawful under the laws of the place where it is committed or would have been unlawful in the United States and which involves any of the following. So, hijacking or sabotage of vehicles, aircraft, or vessels, taking hostages to issue demands, violently attacking an internationally protected person. Now, this bottom line, this is a really important line here. So, when we look at those terrorist activities defined, I think for many of us, these can be pretty obvious in terms of what would constitute a terrorist activity for purposes of this bar. Another one that's really important to keep in mind is that this does include situations and circumstances where an individual has offered what's called material support to a terrorist organization. So this could be money, this could be food, this could be transportation. So it is always really important to look beyond kind of the obvious acts and always inquire as to this material support possibility whenever we're working with an applicant. Now, we also have the persecutor inadmissibility ground. So, an applicant is inadmissible if they ordered, incited, assisted, or otherwise participated in the persecution of any person because of race, religion, national origin, or political opinion. This also may apply to applicants who are part of the military, police, or members of the government. Now, we also have the firm resettlement bar. So, an applicant is ineligible if they were what's called firmly resettled. Now, an applicant is considered to be firmly resettled if, prior to arrival in the United States, they entered into another country with, or while in that country received, an offer of permanent, just repeat this one more time, permanent resident status, citizenship, or other type of permanent resettlement, unless they are able to establish that entry into that country was a necessary consequence of their flight from persecution, that they remained in that country only as long as was necessary to arrange travel, and that they did not establish significant ties, or that the conditions of their residence in that country were so substantially and consciously restricted by that country that they were not resettled. Now, just to continue with this bar, some particular issues that we tend to see with TPS applicants can be things like dual nationality, long periods in third countries before coming to the United States, offers of temporary protection in third countries, and lawful permanent status in a third country, as well as children that have been born in third countries. So, this definition indicates that firm resettlement requires that the applicant actually entered that third country and that the status that they were offered or held there was permanent. So, once again, permanent in nature. So, what does this mean? This means that traveling through another country, living and working without status in another country, or possessing a type of temporary or limited form of status from another country will not trigger this bar. So, for purposes of TPS eligibility, USCIS considers an applicant to be firmly resettled if prior to arrival in the United States and subsequent to the events giving rise to the TPS designation itself, they entered into another country with, or while in that country received, an offer of permanent resident status, citizenship, or some other type of permanent status. Um, at the time in the third country when the resettlement status was offered or held must have occurred after events giving rise to the TPS designation. Now, another inadmissibility bar here, um, human trafficking. So, admissibility problems could arise concerning human trafficking. So, any person who commits or conspires to commit human trafficking offenses in the United States or outside the United States or who is believed to have been a conspirator or colluder with respect to severe forms of trafficking. All right. Now that we've taken a look at all these grounds, all these bars, we're going to talk about waivers a little bit. So, some grounds of inadmissibility are automatically waived. These are the easy ones. So, this could be entering without a valid visa, entering to work without a labor certification, or being a public charge. Some admissibility grounds cannot be waived. So these are going to be our certain crimes and drug offenses, those terrorism grounds and national security, as well as Nazi persecution and genocide. So, how do we waive? USCIS may grant a discretionary waiver for some grounds based on humanitarian, family unity, or public interest reasons. So, practically, how do we do that? So, we'll file Form I-601, the application for waiver of grounds of inadmissibility, along with the I-821 to request a waiver of inadmissibility grounds. Okay, so now we've set the stage here. We've looked at bars, we've looked at eligibility criteria, admissibility versus inadmissibility. Now we're going to get to the really fun part, talking about the TPS application itself. And this includes forms I-821, I-765, and I-912. And just a reminder, I know Allison went ahead and put these in the chat, but just to keep these open while we take a look at these forms. So the I-821 itself and filing. Now, USCIS will allow initial TPS applicants to file online through the USCIS portal or through a hard copy application by mail. So, you'll have the I-821. This is the actual TPS registration application. The I-765. This is your application for work authorization to get what's called an EAD, your employment authorization document or card. You'll also enclose filing fees, or you're going to enclose Form I-912, a request for a fee waiver. Now, one really important note on if you are requesting a fee waiver, if you are completing that Form I-912, if you're using this form, the TPS application, or in general, any application that's needing a fee waiver, just as a general rule, must be submitted in hard copy via mail. It cannot be filed online. So, taking a look at Form I-821 itself, and we're talking about initial applications today. So, question one, pretty important question. So, you're always going to want to indicate in these boxes that this is an initial application for TPS. So, that would be box 1A. You'll just want to put a nice check mark right there. Now, with respect to work authorization, second question, another really important question. So, work authorization will be a physical identification card valid until the end of the TPS designation period. So, for example, if an individual is granted TPS and a work authorization under the 2023 Venezuelan TPS designation, the work authorization will be valid until April 2nd, 2025. Now, apart from the actual employment authorization document itself, a social security card and number will also be generated for the applicant. Now, applying for a work authorization document is optional, but is strongly encouraged. Now, just an important note here with respect to work authorization. So it is very common for TPS applicants to also be asylum seekers. So if eligible to apply for an asylum-based EAD, which is under the EAD code C8, or if already pending, or of course if already obtained, a TPS-based EAD is not needed but may still be recommended. Now, why might we still recommend this? So we still might recommend a TPS-based EAD if the applicant has had issues with what is called their EAD asylum clock. So this is for individuals that are waiting for the time at which, after they've applied for asylum, they're eligible to file and then receive their work permit. If there's been any sort of issue, so for example, if someone has changed immigration courts, or there's been any sort of, could also be any sort of administrative error on the government side. If there's any issues with that clock, a TPS-based EAD still might be recommended. Now, and also an important note for those who would like to apply for a CA, an asylum-based EAD, the first EAD for asylum seekers is free. free. So there's no filing fee, no fee waiver needed. It is free. Um, and also, we've had just very recently a really great change in the law that has made these specific EADs, these asylum-based EADs, valid for 5 years. All right. Now, something else that you will hear me continue to harp on a bit as we continue today, an important note on mailing addresses. So, for all applications. So the IE21, 765, 912, everything. It is absolutely critical that the applicant's address is correct and current, and the applicant can, in fact, receive mail at that address. Now, because these are pro se applications, oftentimes we must confirm the mailing address. So it's just always really important that we're double checking that address, that we're speaking with our community members and making sure that, again, it's not just an address, but an address that they can actually receive mail at. So, for example, I will always tend to ask, oh, have you gotten mail at this address before? And that's always just a good way to confirm that, okay, if we've file all these applications, if we send everything out, if they send everything out, that they will in fact get their receipts and then any important information that may follow. Okay. So to move along on the I-821 itself, we'll take a look at questions 22 through 24. So the date and manner of entry to the United States. So the date of entry can be verified by a passport stamp, an I-94 or I-95 entry document, or the notice to appear, that NTA that we took a look at just a little bit earlier. So some examples also of the status that you had at entry might be a B2 visa, a visitor. If, like many of our community members, you were paroled in, it'll be paroled. And one really important note here is that if there was any sort of entry without proper documents or with fraudulent documents, it's still noted as an entry, not as an entry without inspection. It does still technically qualify as an entry. Now, this date, of course, is really important for TPS. So, just as another example here, if we have a community member that's applying for Venezuelan TPS under the 2023 designation, this date that we're plugging into the box must be prior to July 31st, 2023. Now, another method, if you are trying to verify this date of entry, so if the applicant does not know their travel dates, you can look it up sometimes on the CBP website, which we have a link of right here. The site will need the person's name, date of birth, passport number, as well as the country of issuance for that passport. Now here we have a really pretty red circle that shows you exactly where you need to go. So that is the box that you want to go ahead and click on if you're trying to obtain this information. All right. Now moving on to question 26, which inquires as to current immigration status. So for example, if the person was paroled into the US, you'll put parole for question 26. If they have a valid visa, please describe that visa. So a student visa F1 or visitor B2 are the most common that we tend to see. Now, if they have another application pending or another manner of entry, this would be a situation in which we'd say for advocates to please ask for assistance just to make sure that everything with respect to that status is able to be described correctly. Now, if none of that applies, you can always write none if there was just absolutely no status at that time. Now, moving along as well, just a little bit below, we have our questions as to immigration proceedings. So, of course, we have the question, are you now or were you ever in immigration proceedings? So if the person crossed the United States border, they may have been issued a notice to appear, placing them in removal proceedings. If they have applied for asylum or another benefit in the past and they were denied, they may have been in proceedings in the past. Now, one really important note, that's why we have it bolded, is that past proceedings, even those that resulted in a deportation or removal order, are not a bar to receiving TPS. All right, just taking a sip of coffee, a lot of talking today. So moving along here on the Form I-821, parts 4, 5, and 6. Again, we're discussing initial applications today, so these will never be filled out. because these are not late initial filings. So no information is needed as to spouses or children. So to continue on here, we get to the eligibility standards section. So if we take a look at question 1B, and for the purposes of TPS, we need to have this date that's applicable in the designation and registration periods that we're discussing. So again, going back to our example here, the Venezuelan 2023 TPS, in this box, we want to make sure that we have a date that's before July 31st, 2023. Now, another important note on this section is the countries in transit box. So this is question 2 in this section. So oftentimes, not always, but oftentimes, our community members will have traveled through many countries before arriving here to the United States. Now, it's really important that we list all those countries and that we have the correct time period in total. So, never be afraid of using Part 11 on page 13 if you do need more space. If you're trying to list off 8 countries, it's really important that we have all 8. So make sure that you use that additional information section to go ahead and plug all of those countries in. Now, continuing on with eligibility and the eligibility questions. So if we take a look at pages 7 through 10, these pages contain a highly varied list of questions that aim to get at the admissibility, which we had discussed in depth before, of the TPS applicant. So, following from the standard criminal history questions, you will also see many and highly variable questions, which inquire as to things like political party membership, military service, service in a jail or prison, past polygamy, and many, many others. So, as they affect the admissibility and therefore the eligibility of the applicant, these questions should always be approached with caution and be very carefully reviewed. And if working with a community member, a brief warning as to their content is always advisable, just so as you're going through the questions with the community member, there's no sort of shock or surprise element, that there's at least a bit of a heads up before diving into a bunch of just really variable and often personal questions. So if we take a look at some examples here, so we'll take a look at question 22. Now, this question asks, have you ever assisted any other person to enter the United States in violation of the law? Now, many migrants cross with family members and oftentimes with small children. So the best practice here is to indicate no on this question. So no, we answer the question no, while explaining on that additional information page that the applicant entered with their child or family member to save their lives, to seek asylum, or or to seek humanitarian protection. Now, we respond this way under the theory that everyone has a right to seek asylum, no matter how they entered. So basically, what we're doing here is that we're not hiding anything, while we're also not admitting anything. It is not illegal to present yourself at the border, at a port of entry, and to request asylum. So looking at another example, another common one that we see, we have question 31A. So this question asks whether an applicant has ever served in, been a member of, assisted in, or participated in any military unit, paramilitary unit, police unit, self-defense unit, vigilante unit, rebel group, guerrilla group, militia, or any sort of insurgent organization. So just as an example here, if you are working with an applicant that has served in the military, it is very important to ascertain all the details of that service, and if needed, to also obtain an expert opinion, especially if the applicant is from Venezuela or another country with a noted record of persecution which has been carried out by the military. Okay, so switching forms a bit here. So moving on from the I-821, that actual TPS application, to the form I-765. So this is our application for employment authorization. Now, the information that we need to complete this, same basic information as on the I-821. So date of entry, date and place of birth, current address, etc. We also will need a few different pieces of information, including the name of the applicant's father and mother, This is needed if you're requesting a social security number, as well as the status at last arrival, as well as current status. So, for example, if an individual is paroled in, but the parole has expired, status at arrival would be parolee, and the current status may be none, or maybe something like asylum pending if they have applied for asylum. So, taking a look at the Form I-765 itself, on page 1, you'll always want to check off 1A. This is your initial permission to accept employment, since this application that we're talking about today is based on an initial TPS application. Now, also, if we take a look at page 3, this is where we'll get to the actual eligibility category. So I discussed earlier, employment authorization documents will always have a code. So for example, we briefly talked about that C8, that asylum EAD. So please note that for TPS, there are two EAD categories for TPS. So we have A12 for granted TPS, and USCIS may also issue an EAD under eligibility category C19. This is for those with a pending Form I-821 and who are prima facie eligible for TPS. Now, for initial applications, we recommend that the code that should be used is going to be C19. Now, switching to another form here, the Form I-912. So this is your request for a fee waiver. So one really important aspect of this form is that I-912 can cover all forms being filed and all members of a household as well. Now, this can be requested on 3 grounds, which of course must be supported by evidence. So our first ground is if they're receiving a means tested benefit. So this could be Medicaid. What does this mean? If if a spouse or head of household is receiving public assistance in their name, such as Medicaid, cash assistance, SNAP. Our next ground is whether they have income that is below 150% of the federal poverty guidelines. Don't worry, you do not need to do the math on this. We have a great link for you that takes you exactly to the website that has a nice, pretty chart that will show you exactly whether or not someone falls under the poverty guidelines by household size as well. So anywhere from 1 person up to something like 5 or 6. That chart will be able to let you know where you stand in terms of the federal poverty guidelines. Now, finally, we have financial hardship. So this may include, but is not limited to, medical expenses of family members, unemployment, eviction, and homelessness. Now, really important note here, you can choose more than one basis for a fee waiver. So you're not stuck with one. All right. So looking at this in a practical manner here. So here's the actual form. Here are our grounds. Here are the boxes. So you'll check whatever box to indicate on what grounds you're requesting the fee waiver. Now, I know I just said this, there's a reason I'm saying it a lot. You can check one or you can check all. These grounds are not exclusive. And in fact, if someone is able to check all 3 boxes, we recommend that they do so. It's essentially just 3 bites at the apple here, 3 grounds that the adjudicator at USCIS will be able to take a look at. So always keep in mind, grounds are not exclusive. If you can meet all of them, go ahead and check all. Now, looking at a little bit more on this form. So if we look at part 3, so this is where you're actually indicating the applications or petitions for which you are requesting this fee waiver. So if we look on our left side, that's where we're going to include the names of all family members included with the waiver. And if we move over to the right, that's where we're going to include all the forms being filed. So, for example, for an initial TPS filing, the forms will be an I-821 and an I-765. Now, if we take a look at the very bottom box on the right-hand side, this is where you'll add up all forms for all family members. So, if we have a family of 4, that are all applying for TPS and work authorization. So 2 forms each, that box should have 8, just as an example here. Now, how do we provide evidence that supports our fee waiver? So for means tested benefit and evidence of receipt of public assistance in the form of a letter, notice, or any other sort of agency documents that indicate that the benefit is being received. Now, the income-based ground, a copy of each household member's most recent federal tax return, copies of consecutive pay statements for the past month, a W-2, an employer letter on business stationery that shows your salary or your wages, any evidence of financial assistance, so child support, alimony, parental support, unemployment benefits, pensions, social security benefits. Now, in terms of financial hardship, any sort of proof of income and any evidence regarding the type and the value of any assets. All right. So, switching gears here again, we're briefly just going to go through advanced parole, which we had mentioned at the onset of this presentation. So, this is a document, a travel document essentially that USCIS may issue within its discretion. So, it's completely up to USCIS whether advanced parole is to be issued. So, what is advanced parole? Now, to be allowed into the United States, a person must have a visa, lawful permanent residency, or be a U.S. citizen. However, CBP or ICE may grant a discretionary permission for immigrants without a visa to enter the United States through humanitarian parole. Advanced parole is a preemptive adjudication of this parole in advance of travel abroad. So advanced parole is optional. It can also be filed concurrently, or it can be filed after the TPS case, the TPS application is approved. But it does take a few months to be adjudicated. Applicants should not leave until the advanced parole is approved and documentation provided. So just to hammer this point, applicants should not leave until the advanced parole is approved and they have that documentation in hand. So, some practical steps for advanced parole here. So, as we had mentioned, you can file the form I-131, your application for advanced parole, concurrently or after filing the I-821 TPS application. Now, it's important to keep in mind there is a separate filing fee for advanced parole. And then a really important note here, a fee waiver is not available for advanced parole. So in a situation in which a community member has submitted a fee waiver for their I-765 and their I-821, they cannot do the same thing with this I-131. They will have to pay the fee. So that's always something that's really important to keep in mind when working with our community members. Now, if advanced parole is granted, the permission to travel may be included on the work authorization document or may be issued through a separate document. Now, a really, really important warning here. Many applicants who are eligible for TPS have pending affirmative asylum applications and or are seeking asylum in removal proceedings. Anyone who is claiming asylum from their country of origin cannot travel to their country of origin. USCIS generally will also not issue advanced parole for those individuals who are in removal proceedings. Now, to continue with our important warnings here, a grant of advanced parole does not guarantee reentry to the United States. A TPS applicant may be denied admission to the United States if there was any sort of misrepresentation on their TPS application or any other application, criminal, national security, or other inadmissibility grounds, if the TPS application was denied or revoked, and if there's a prior order of removal. So now that we have all the information, we know what TPS is, we know how to qualify, we know what goes with it, we're going to take a look at actually preparing to file for an initial TPS application, the packet, the TPS packet itself. Now, just as a really quick note, for Pro Se Plus Project volunteers. So all the fantastic volunteers that come and volunteer with us. So if you're volunteering with us at a PSPP clinic, we handle all follow-up after the clinic. So this includes filing the applications themselves. This also includes conducting a final review, any needed applicant follow-up, ascertaining the correct mailing address to actually file the applications, and then, of course, filing the applications themselves. Now, when we're assembling and putting everything together, we'll, of course, be putting our supporting evidence with these filings. So just to kind of look at the standards that our supporting evidence has to reach, the applicant bears the burden of demonstrating eligibility. So the burden is on the TPS applicant. The sufficiency of the evidence itself will be judged according to its relevancy, consistency, credibility, and its probative value. Now, and this is a really important point here at the bottom, note that if any required document is unavailable, an affidavit or other credible evidence may be submitted. So this is a situation in which a document may be missing. Um, you always have this option of putting an affidavit together or any other sort of credible evidence that may be able to fill that gap. So just always keep that in mind. Now, another incredibly important, actually, I'll change that. Two more really important notes on supporting evidence. So accompany all foreign language documents with an English translation and a translator's certification stating that the translation is complete and accurate and that the translator is competent to translate from the foreign language into English. So what this means is that we can never submit documents to USCIS that are in a foreign language. So, for example, a birth certificate from Venezuela needs to be translated and it needs to have this certification. Now, another crucial, really important point here, we always submit photocopies of documents, not originals. So we always keep original and the government always gets the photocopies. So, some examples of supporting evidence that you might include. So, as to identity and nationality, it might be a copy of the biographical page of a passport, a copy of a birth certificate with a photo identification. For continuous residence, you might have something like that I-94 arrival departure record, travel records of plane, bus, train tickets, school records showing you or your children attended school here in the United States, hospital or medical records, or applications for medical insurance, rent receipts, utility bills, letters from companies, commercial receipts for purchases, letters from church, from a synagogue, community groups, legal screenings, etc. And we can go through this very quickly, especially since we tend to, and we've reviewed a lot about a fee waiver, but just so we know what we're looking at in terms of what the actual filing fees are, and if we have community members that, of course, are able to pay these filing fees, that want to pay these filing fees. So generally, and the most common will be an initial TPS application, which is also requesting an EAD. So we'll look at the first, it's our second line here on the chart. So normally going to be an individual 14 to 65 years old. You add all those individual fees together and you'll come up with a final amount of $545. So the filing fees are expensive. And if we also just take a look at our filing fees for advanced parole, you'll also be able to see, especially if you file concurrently, these filing fees can really add up. Okay. So actually preparing and filing the packet. So you are responsible for filing the TPS registration packet with USCIS. So the packet will include forms I-821, I-912, and I-765, and if filing concurrently, that I-131. That's that advanced parole application. Now, if there's no I-912, if there's no fee waiver, you'll enclose a check, money order, credit card authorization for the filing fee, as well as a separate check, money order, credit card authorization for that $575 filing fee for that I-131, that advanced parole application. 2 or 4 passport style photographs of the applicant, evidence of the applicant's identity, evidence of applicant's entry to the United States, evidence of the applicant's physical presence, evidence of applicant's continuous residence, and evidence of past immigration history, immigration proceedings and outcomes, and any sort of criminal dispositions as well, if applicable. Okay. I warned everybody that I was going to I was going to harp on mailing addresses, so here I am again. So mailing the application. First of all, please make a copy of all documents before filing. Always keep a copy. it is just absolutely essential to always keep a copy of everything that's been submitted to the government. Now, for TPS specifically, each country has a different filing address for TPS. So it is absolutely critical to check the country specific page for the correct address. So we've conveniently put down the link here where you'll be able to just click onto the TPS homepage. If you look on your left side, you'll see a whole list of all the countries currently designated for TPS, and you'll click there in order to go to the country specific page. Now, um, because USCIS and the government wants to make things even more fun, the filing address will also depend on what state you're in. So California, New York, etc., as well as the mail service that you're using. So we just have an example here. So for filing a Venezuelan TPS application in California via USPS, you're going to be able to find that filing address right below where it says USPS on that right-hand side. So everything's filed. What happens after the filing? So applicants, as we stated before, should keep photocopies of all filings. So this would also include a check if fees were paid, as well as copies of those passport style photographs. Now the applicant will receive a notice informing them of a date and a time to appear for fingerprinting. Um, they must appear for fingerprinting and biometrics. USCIS may also send a request for evidence, which we shorthand to an RFE, asking the applicant to provide more documentation about their eligibility. Now, if you had been wondering why I was harping on addresses all today, this is the reason why. So it is absolutely essential that our community members are able to get all of these important notices via the mail. So, as an example here, if there's an RFE, this request for evidence issued, and it's just sitting in a mailbox at a prior address, that TPS application will be denied. If there is no response to that RFE, you're back at square one. And of course, no one wants to be in that situation. So this is why we harp on those addresses. We want to make sure that all these important documents are arriving to our community members. All right. And to go along with my theme here of addresses. So if the applicant moves after their TPS application is filed, they must inform USCIS by filing their change of address on Form AR-11. And this is available to file online. Now, another really important point here on my favorite subject of addresses. Applicants who move before they have received a receipt notice for a pending application. So it could be TPS, could be asylum, should always also change their address with USPS in order to ensure that they receive all those important documents that we discussed. That fingerprint appointment, that request for evidence if one is issued, it is absolutely critical that they receive those documents. So a USPS change of address can be done either online at the link below or in person at your local USPS office. Now, here we have what we all shoot for, right? This is what we hope for, an approval. So USCIS will adjudicate the TPS application and the work authorization via mail. When the TPS application is approved, they will send an approval notice, a Form I-94, and the employment authorization card to the address. And again, the correct current address that our community members can in fact receive mail at that is indicated on that I-821 and that I-765. Now, a Social Security card will also arrive if one was requested on the I-765. This again can be concurrent or it can take an additional anywhere from about 2 to 6 weeks. Now, there is really no estimate on how long it will take for the TPS and TPS approval and the employment card to be issued. This all depends on the resources that the government is allocating to the effort of adjudicating these applications. So roughly we say anywhere between about 3 to 9 months. Now, if we don't have an approval, obviously we have the option there could be a denial. However, denials of TPS applications are exceedingly rare, given the really straightforward nature of most of the eligibility criteria and the lack of a discretionary element to the adjudication of these applications. However, one really important point is that denials, if a denial is received, may be appealed within 30 days to the Administrative Appeals Office, shortened to AAO, at USCIS. And just a quick note here on re-registration. So we've been talking about initial applications all day today, but just to review this quickly here. So at least 60 days before the expiration of a country's TPS designation or extension, the DHS secretary, after consultation with appropriate government agencies, must review the conditions in the country designated for TPS to determine whether the conditions for the TPS designation continue to be met. Now, if it's extended, there will be an open re-registration period, which requires the filing of a new I-821 and new I-765 applications, either with new fees or with new fee waiver requests. And with that, we will open it up to any questions. And we also have here just how to reach the NILAG PSPP team. You can reach out to us via email. We have our phone number here, as well as our website. So on that note, thank you everyone so much for being here today. Thank you for your commitment to this work. And we'll look forward to hopefully seeing a lot of you in the future. And again, just to really emphasize this, we could not do the work that we do on my team without all of you. So just a huge thank you from us.